Today's presentation is entitled Legal Tools to Protect Children of Undocumented Parents. I don't think I really need to give too much background on why we're doing this topic right now, as most of you likely read the news. Today's presenters are attorneys Courtney Rotlands and Angie Feliciano, both with the Legal Aid Society of Milwaukee. Courtney is the Assistant Managing Attorney for the Children's Court Guardian ad litem Division. Her practice focuses on child welfare cases, minor guardianships, and termination of parental rights cases, with a specialization in appeals. Over the last 2 years, Courtney has argued 4 cases before the Wisconsin Supreme Court, focusing on the rights to counsel and other procedural issues in TPR hearing proceedings. Angie is the managing attorney for the immigration team with the Legal Aid Society of Milwaukee, and her practice focuses on initial asylum applications, work permits, and adjustments of status. The immigration team hosts various clinics throughout Milwaukee that primarily focus on preparing power of attorneys for families. Thank you both for being here today, and I will turn it over to you.
Hi, everybody. My name is Courtney Rowlands. Again, I'm the Assistant Managing Attorney for our Children's Court Unit. I'm going to get us started today. My co-presenter, Attorney Feliciano, is on her way here from a clinic this morning for immigration work. So let me just figure out how to get the slides shared.
We can see them.
Thank you so much. So again, this is kind of going to be a presentation on how to give kind of a refresher on how to do a brief legal advice clinic, specifically in the realm of powers of attorney for over children. I'm going to start off talking a little bit about the child welfare considerations, and Attorney Feliciano will talk more about specific immigration laws and concerns to keep in mind when preparing these powers of attorney. So we'll just kind of talk a little bit about why this is important right now, child welfare laws, and then Attorney Feliciano will take over with talking about immigration laws and get in specifically to what a power of attorney looks like. As Katie mentioned, it probably goes without saying a little bit why we are all here. Actually, as I was logging in today, I had another headline about ICE arrests at courthouses nationwide. There has been a presence at the Milwaukee County Courthouse and in businesses in Milwaukee. It has caused quite the chilling effect on court dates and court appearances for individuals who are afraid of what is going on. People are missing court dates, they're missing work, only going out for essentials. One thing that we kind of can do as lawyers is talk to people about a lot of judges are willing to do remote appearances during this time. And in this context specifically of powers of attorney, they do not need to be filed at the courthouse or with the court. They just need to be kept in a safe place that is accessible to both the parent and the person that they are giving parental power to. So that is one way to kind of go through this process without kind of exposing community members to some of the activities going on. In Wisconsin, child welfare is governed by Chapter 48 of the Wisconsin statutes. Children can be removed from their parents for a variety of reasons. Most specific or relevant today would be incarceration, hospitalization, or other institutionalization without provision for appropriate care. So if a person was picked up by ICE, a child could be put into foster care if there were no provisions for appropriate care made prior to that incarceration. Children can also and are most commonly removed for abuse and neglect situations as well. So again, individuals who are detained by ICE without a plan in place ahead of time run the risk of their children being placed in foster care due to neglect or unavailability without provision for appropriate care. So the point of this presentation is to help people put in provisions for appropriate care. Kind of as an outset matter, when kind of talking to individuals who are looking into creating these powers of attorney, it's important to kind of get some background information about the family dynamics with that family, because every family is different. Your brief service client might be an immigrant parent with US citizen children, could be a situation where they have a US citizen co parent. Your client could be an immigrant parent with an immigrant co parent and US citizen children. Some children might also be undocumented, or all of the children could be undocumented. So a plan should be made that kind of considers the whole family, but you should get some background information as you're able to, because the plan might be different for each child. Once you kind of understand what children might need, powers of attorney, which children might have US citizen co parents, where custody could be arranged with that co parent, you should help individuals kind of identify a caregiver, and in some cases, also a backup caregiver. This is any person that the client trusts who is willing and capable of caring for the child long term. This can be a relative, it can be a family friend. The most important part is that the person is willing and capable of caring for the children, and that they do not have CPS history or criminal history. As to CPS history, I would encourage you to have people identify somebody with just zero, no CPS history. That's the safest option. As to criminal history, it's preferable that the person have no criminal history whatsoever. But particularly, the person should not have any criminal history of crimes against children, including physical abuse, neglect, sexual abuse, or other violence. And nobody in this caregiver's residence should have CPS history or criminal history either. So if you've identified a caregiver, but their brother is living in the house and that individual has a criminal history with crimes against children, that's not going to be an option that fully protects from CPS getting involved and potentially removing those children later if the parent becomes unavailable. This should also preferably be somebody who is not also at risk of deportation. However, if the perfect person to be the caregiver for the children is also at risk, perhaps then identify a backup caregiver that also meets these criteria. Another thing that will be helpful to create kind of at the time of drafting the power of attorney will be kind of talking to your brief service client about the important information for caring for the children and getting all of that written onto a document and essentially kept with the power of attorney document. Um, this document should include critical information for appropriate care of the children as applies to that child. So that child's name, date of birth, instructions on where to locate a social security number if it exists. Probably wise to not just put socials on a bunch of random documents floating around to multiple people, but instructions on where to locate it. Education information, if it exists, for school, daycare, teachers, contact information for the school, pickup and drop off times, the location of that pickup and drop off, medical information, any medical information that's relevant. It could be as simple as just the primary care or pediatrician information. And depending on the age of the child, go up and through dental, potential pharmacy or medication lists, logins for my chart or live well, and any explanation of special needs if applicable. If the child is on some kind of daily medication, instructions on where to locate that medication, what the dosages are, and how to get a refill. Um, Again, this is really going to be dependent on the child, but basically anything that somebody would need to be able to pick up and start caring for a child on a daily basis without notice. This document could include information on any financial savings that your brief service client may have for the children available and how to access it, and emergency contact lists for each child if something were to happen. Once this document is created, it should be sent to the caregiver and the backup caregiver. Step 3, what we're really here for, the power of attorney delegating parental power. A parent is able, under law, under Wisconsin Statute 48.979, to delegate most of their parental powers to another individual without depriving the parent themselves of any of his or her own powers regarding care, custody, and control of the child. These delegations are legally effective for 1 year, with some small exceptions being that if the delegation is made to a legal relative, so the definition of a legal relative, it can be legally effective for over a year and up through any expiration date. And a delegation to somebody who is not a relative can be approved by a court for a longer period than 1 year. Now, again, we talked about earlier, probably wise to be trying to avoid the courthouse. So it could just be a situation too where we draft the power of attorney with a 1 year expiration, and it could be redrafted each year for as long as they may be necessary. While not in the scope of this specific presentation, there could be cases where a power of attorney does not seem permanent enough, where 1 year or coming in every year maybe isn't the best scenario for the brief service client or for the children. There are other options, such as guardianship of a minor under Wisconsin Statute 48.9795. If that seems like something that would be good for the brief service client, there are organizations and nonprofits in the area that assist petitioners and parents with guardianships, primarily including Kids Matter. So that referral could be made. With that, I am going to turn it over to my co-presenter, attorney Angela Feliciano.
Hi. Hi, thank you, Courtney. Can you guys hear me okay?
Everything sounds good. And I'm just going to also put in the chat some links to documents we've prepared in partnership with Legal Aid on this topic. If people are looking for templates to use, we have them available in English, Spanish, and Hmong. So I'll drop those in the chat for people to use too.
Perfect. Thank you so much, Katie. Perfect. Thank you all for joining in, and I apologize for being late. I was actually at a clinic that overlaps with the document that Katie will be sharing in the notes with that power of attorney for minor children. So I apologize for being late. I'm here now. So this is an interesting overlap, right? Between immigration law and family law, when we think about parents without status, and what the family makeup looks like in today's day and age. Every family looks a little bit different, but given this current administration, this specific power of attorney came out of the idea of the MBLC and legal aid, and thinking of how to prepare families if they were to be detained and eventually deported. So we have been working with this template that Katie dropped in the chat since I think the beginning of this year, and Legal Aid has done a couple of clinics with partners in the community, one-on-one, but also we prepare them at the MBLC on Wednesdays from 5 to 7. And Legal Aid is at Sojourner 9 a.m. to noon on Tuesdays and Thursdays, alongside the new MBLC immigration line that just launched, I think, this week. So all of that information, I'm sure Katie can circulate along with flyers for those who are interested to spreading that. Because Legal Aid and the MBLC work very closely together. And so, yes, getting into the immigration law aspect of this presentation. So we always have parents who come in to these clinics in our office scared of what the future holds under this current administration, and we always remind those individuals that even without status, they have constitutionally protected rights, which include the right to remain silent, and that's whether when questioned or arrested by ICE, and the right to be secure in their own home. And unless ICE has a judicial warrant, they can't access those private spaces, whether it be in their home, in their car, or if they're in a public building, if there's marked private spaces, ICE must have a judicial warrant to access those spaces. And so reminding people that they have rights, even when encountered by ICE, I think is a really important part of interacting with any clients that come through the MVLC, or that you just, might encounter out in your day to day. Yes, and getting into the ICE warrant. So ICE warrants are just administrative forms that are prepared and signed by ICE agents themselves. And so when we talk about ICE warrants, they are usually for civil immigration violations, and they're different from criminal judicial warrants. Um, and so when we say that, ICE is not allowed into private spaces such as people's homes without a judicial warrant, and if they only have that ICE warrant, it doesn't hold that power that a judicial warrant has, because it's for a civil immigration violation and not a criminal offense. And so if reminding clients, or even, the MBOC has for their clinics, in-person clinics, they have private spaces that clients can sit and wait for services that aren't allowed to be accessed by ICE agents. And so when an ICE agent does enter a home, they need a judicial warrant, which has to be signed by an immigration judge, has to name the specific individual, and it has to name the specific address in which they are to search. So if they have a judicial warrant signed for the client's home, but it's actually they're executing it at the client's place of work, that doesn't match up, and so they cannot access that a private space within the client's work location, because that's not the correct address where they're to be executing the warrant. Now, obviously, if they do have a judicial warrant that names the individual and names a specific address, then we do have to, advise the client to let ICE come in and search for the individual, and take that individual away. Now, when it looks like after being detained, by ICE, they still have rights. They do not have to sign any paperwork if it's not in their native language. If they don't understand any portion of the documents that they are signing, they cannot, they should not, I should say, they should not be signing anything they don't completely understand. And I always get, when we do know your rights clinics or presentations for organizations in the community, one of the questions that always comes up is, well, you say to do all these things, right? Don't run, don't resist, don't lie about your status. And then the ICE agent isn't like, it's not a transaction, right? It's not like, oh, well, the ICE agent says this and the client says this, and it kind of goes in a neat order. If I'm sure we've all seen either on our social medias or on news coverage, footage from individuals who are recording ICE interactions out in the community. It's chaos, right? It's ICE agents yelling instructions, and there's families that are crying and yelling and, begging ICE agents to not detain this person, to not take them away, asking for identification. So it looks very rambunctious and very, crazy and disorderly when the actual interaction is taking place. But that's why it's important to, kind of reiterate all of these things to the community and to the individuals who come through the MVLC, is to, not run, not resist, especially don't lie about status, because that can harm them in any immigration case they have in the future. Lying about a status, if they say U.S. citizen or legal permanent resident when they are not, can really hurt their case. If it, especially if it's captured on footage or anything like that, it will be used against them. And so, really not saying much or anything at all, is the way to go if they were to encounter ICE. Um, and then asking for a phone call. Now, it's not that's not constitutionally protected to get a phone call, but they can always ask for one, and the ICE agent could give them a phone call, whether that be to their partner, to a family member, informing them, hey, I've been taken, hey, I've been detained, this is where I'll be. If they already have legal proceedings, immigration legal proceedings occurring, they'll have an A number, and that's alien number, but we use A number for short, that identifies them uniquely within the immigration system. And so, individuals who have an A number, it is very important to memorize that number, but also for their family members to have that number easily accessible so they can, that's how they're identified. They don't ask for last name, first name. They say, hey, what's their A number if they have one? And that's how they're located kind of within the immigration system. Usually the Executive Office of Immigration Review, that's how they'll identify them if they're in a defensive immigration legal proceeding. They still have the right to be in front of an immigration judge and request a bond, or to be released on their own recognizance, or under supervision. And that supervision just looks like ICE check-ins. With this request for bond, and then or a request to be ROR, it's up to the immigration judge, and basically the client is advocating for, why they should be released on bond or not have to pay and be released on ROR. And those factors include, right, like if they've been here for a really long time. Most individuals have been here for 10 years plus, no criminal history, have family here, especially when we're talking about this like family setting, right? If they have minor children, saying, hey, my kids they need their parents in their life. So all of those good factors that go against either getting that bond or just released on their own recognizance, that's the time to plead their case in front of the immigration judge while they're pending any other removal proceedings. Because once they are arrested or detained, and if they do not have status, if they not are already placed in removal proceedings, they will be placed in removal proceedings most likely. And so that'll kind of kickstart the process once they are detained with ICE. And then just again, not signing any paperwork, advising clients not to sign any paperwork without understanding in their native language what they are signing. A lot of the time, ICE will try to trick, deceive clients into signing their own deportation order. That's very hard to fight in immigration court. Once they sign off on that deportation order, it's kind of a signed and sealed case to be removed out of the country. And so we always remind clients not to sign anything unless they know exactly what they're signing. Now, some clients are not willing, I guess, to fight in immigration court. And so some people do sign and say, hey, yep, just, return me back to my home country. But unless they completely know that they will be ordered removed, they should not be signing anything. And of course, always having someone to contact, like an immigration attorney, is imperative for those who are detained, so they can have someone at their bond hearing if they need to. But most importantly, so they don't get lost within the system through the kind of ALA connections. We've been hearing that a lot of detainees are being transported out to Kentucky. That makes it harder for clients to get in touch with loved ones, makes it harder to get in touch with immigration attorneys here, in the community that they're from. And that's done intentionally, unfortunately, to make that harder to receive any kind of aid or help. And so just, having someone to call or a list of people to call is important. So. And then now getting into the actual form, and Courtney, I don't know if you have it on hand
Can
to
I
share
jump,
your
can I
screen.
jump in quick
Oh,
too while you're pulling it
absolutely.
up?
Yeah.
Just to do the attendance code and then I won't have to break
Yeah.
your nice stream of thought.
Yes.
The first part of the attendance code for everyone listening, and I'll put it in the chat, is the word pumpkin. Pumpkin, traditional spelling. All right, turn it back over to you guys.
Awesome.
I am working on getting the
That's
form up.
and I can forward it to you real quick. Um, because I have it just clipped with the POA part. Hang on. Anyone have questions while Courtney pulls that up for us, whether that be immigration law related or family law related or the overlap on this power of attorney?
I don't see anything in the chat, but if things trickle in as you go through the form, I'll definitely jump in and let you know what the question is.
Perfect. Thank you so much, Katie.
And I am almost there. Yeah.
Perfect. Yeah. Yeah. Keep going. So all of this,
I was gonna say, Angie, if you want, this is
yeah,
quickly, everybody,
yeah,
what
yeah.
I was talking about when
Yes.
I mentioned going through and identifying critical information for caring for children. We created a kind of blank document in the link that Katie um, put in the chat that kind of gives a template for getting all of this. So the children, their date of birth, insurance company or Badger care numbers, IDs for the children, insurance IDs, the pediatrician name and location, my chart passwords, special needs, medications, dental, school. So you don't have to remember what all of those things are. We do have a template for that. And here's the power of attorney.
Yes, perfect. And again, this entire packet I think is very useful for clients, like client facing, but also for practitioners just to go through. It kind of delineates the entire process from preparing a plan for those without status, but also, when they are detained, what that looks like after. And so this whole packet is I think very useful, and it's something to keep kind of in your toolbox if the need were to ever arise. But yes, this power of attorney, delegating that parental power, it's very straightforward. So the first part is naming all of the minor children. And again, families are very blended in today's day and age. And so some families might have older children who are no longer 18, but this is specifically for minor children. And so you won't list anyone who's 18 or older, even though, they're still their children. This is specifically for the minor children.
Angie, one quick
Yeah,
question. It was put in the chat, wondering if ICE, does it need not have individualized suspicion to act?
no, not anymore. So ICE can stop and ask questions of anyone and ask for, paperwork, whether that be a driver's license, whether that be a green card, and that can be based off what they look like, unfortunately, now. There has been a very 180 change under this administration on what ICE is allowed and not allowed to do. They don't have to identify themselves. They don't have to show their face. They don't have to verify any information. I've seen cases where ICE picks up people and they are US citizens and it's not verified until they're in detainment already and then they'll be released. And so it's really a free for all, and that kind of goes back to why people are so scared, and why, people are saying, you can do everything right and they still take you away, which is correct. You can be a US citizen and still be picked up. And so they don't have to have individualized suspicion. Um, they can look at someone and say, you look a little Hispanic. Let's stop and ask you some questions. So unfortunately, that's where we're at right now, with ICE detainment and stops. So um, jumping back into this power of attorney. So again, just naming the minor children if they have more than three, which is sometimes the case. I usually open up a separate Word document and kind of do the same format: name, date of birth, address. For each child that doesn't fit on this page. On page 3 of this document, I believe, there's a checkbox. Yes, or keep going. Uh, Yes, so this page 4, if there's any attached pages, whether that be naming those additional minor children, if there's additional powers that parents want to delegate or not, you want to check that box just so whoever is looking at this knows that there's additional pages at the end. Um, and then jumping back into that page 1, it just simply asks for the parent's name. And so again, only the parent, and it says this in big and bold, right? Only the parents who have legal custody may use this form, right? So if mom and dad have legal custody, put mom and dad's name down. If they have separate addresses, separate addresses. But again, the parent or parents who have legal custody, they're the only ones allowed to use this power of attorney and sign off at the end. Page 2 gets into so
I'm going to
you can.
interrupt super
Oh,
quick.
sure. Yes,
Lindsay.
please. Yes.
As you can see quickly here, this second sentence says a parent may not use this form to delegate parental powers regarding a child who is subject to the jurisdiction of the juvenile court under sections 4813, 14, 938, etc. This kind of gets into what I was talking about earlier. The best time to do a power of attorney is before any of this happens, because if a child is removed by CPS, it is too late to do a power of attorney. These cannot be used to try to subvert an already open case for abuse, neglect, or unavailability without provision for care. That has to be in there by law, but it's also a good reminder of why we want to be doing these in advance before there are problems. Sorry.
One question in the chat asking about who's responsible for the financial support of the minor children.
So the guardian, the person who becomes the agent, is responsible for taking care of the financial aspect of any and all minor children who are delegated to them. Now, we personally, as an organization at Legal Aid, also prepare a financial power of attorney for this specific reason. Because if, right, like to take care of minor children, it is a financial burden as well, to whoever takes on that role, whether it was the parents initially or the agent. But we also prepare financial power of attorneys. So in case that the agent who becomes the person in charge of the minor children can also have access to the financial piece, whether that be limited to bank accounts specifically like for the children, or um, any and all financial accounts of the person delegating this. And again, they can limit as much as they want. They can put restrictions on it. It's not a free for all. But we also prepare that financial power of attorney so the agent can have access to the money to continue to care for the child. Otherwise, it is fully the responsibility of the agent to financially care for the child as well, in addition to just caring for them physically, taking them to school, medically, things like that.
And I guess I'm going to interrupt there a little
Yep.
bit. Legally speaking, a power of attorney is not removing responsibility from a parent. And that's the distinction between a power of attorney delegating parental power and a guardianship. A minor guardianship under Wisconsin statute 48.9795, the legal guardian becomes the legally responsible individual for caring for a child's financial needs. In a power of attorney, the person is accepting the responsibility should the parent become unavailable. Um, if a child was thereafter neglected, I would suffice to say that it would still be the legal parent who was held responsible in children's court, because the parents still retained all of their powers under a situation with a power of attorney. So, not to make the answer even more complicated, but the person who's identified as a caregiver or backup caregiver should be prepared to be taking on financial responsibilities. But legally speaking, under a power of attorney, the biological parent is going to be retaining the legal responsibility for that and the consequences if it is not done.
Yeah. And that again can all be baked into the plan. Again, if they want to set aside money specifically for this in an account and have access to that, we talk clients through that piece as well, because it is an important one, especially when we talk about money and taking care of the child in that way financially. Awesome. So then this second page of this power of attorney, you're naming the agent. And here it lists one agent. You can name a second agent and an additional page if the first one were to become unavailable or not can't be contacted at the time that they're needed. But this specific power of attorney just has room for one agent to be listed. But again, can always modify it with an additional page to add a second one. And then that relationship to the agent is specific because or important because, as Courtney mentioned, this power of attorney is good for a year unless they have specific familial relationship that falls under that statute that allows it to be longer than a year. And whether they fall into that definition, you'll have to go back into the statutes and the codes for that like long legal definition that we're all used to. And then specifically when we're talking about delegating that parental power, usually clients will just go for the full parental power, make any and all decisions when it comes to the care and custody of the child or children named in that first part. Very rarely do we see parents go through each individual power, but that is an option to do so on this form. And so you can go through every single, parental power listed on here, and there's space to add any additional ones. And of course, you can always add an attached page if they're specific. Usually, I'll see people kind of limit. They'll do full, but then, specific requests. It usually has to do with like religious limitations, and so right, like no blood transfusions for those who are Jehovah's Witness or things like that, like and if they are of the same faith, they should know. But obviously, if they don't practice the same faith, listing those requirements or limitations, things like that, are things to consider and kind of talk through and walk the client through on this form. But mostly it's full parental power that we see get checked off on these forms. And all of the things that this power of attorney does, it also does not do certain powers. So obviously the agent cannot consent to the marriage or adoption of the children because again, right, they're not giving up that parental right. They're just delegating that parental power. So no adoption of the children, no termination of the parental rights, I think is the most important for parents, because they get a little bit weary of like, I'm giving up, my parental rights to my child, and that's not what this is doing. So again, reiterating that piece to them at that point is always reassuring to the client. And then, yeah, can't place them in a foster home, group home, can't enlist them in the army, right? So all of those good limitations, I think, protect the child and should be there. And then this last piece is, at least this last piece that you will fill out with the client, is that this power of attorney takes effect, and it's usually we put the day it's prepared and signed, and then will remain in effect until, and again, it's usually a year unless they have that specific family relationship that can be longer than a year. And even then, having like a specific end date, like a year or two, um, 3 if they are outside of that 1 year bar, I think is a good kind of end date for them. And again, it's always the decision of the parent unless it's limited by statute. Okay, and then this revocation of the power of attorney, this last piece, right, like at any time, this power of attorney can be revoked and for whatever reason from the parent, right? Because they are the parent and this is only good until the effective date or until the parent says, and that can be for a number of reasons, right? Like they gain status or they choose someone else, right? They can always pick a different agent as long as the most recent dated and notarized is the form that will take power, right? And so if they want to change an agent, they can do so, revoke that last one and prepare a new one however many times they want. Of course, within limits, I think, as an organization for us, but they can do it as many times as they want, legally speaking.
Here's a question in the chat asking
Yeah.
whether you've experienced any organization or entity, for example, a school district or a police district that has not recognized the document and the delegated power.
I've never seen that happen, Courtney.
I've only seen it happen in the context of it was executed after a CHIPS case was opened and filed.
So that was too late for them, right? To
Mhm.
do so. Okay.
Right,
Yeah.
and that's that clause earlier that said that it can't be used if the court has jurisdiction under 13, 48, 13, 14, etc. If CPS is already involved, you're like getting too close to the end and then it's probably not going to be recognized.
Yeah. And then outside of that, I've never seen a school or anyone else not recognize this power of attorney in any setting. Like power of attorney, this power of attorney for finance, healthcare, anything like that. It's as long as it's dated, notarized, and signed properly, it should be good to go. And then, like, perfect segue for this last piece. The last piece of this power of attorney is to have the parent or parents who have custody of the children sign off. Now, again, if you have a mixed family, if they have to prepare a number of these for different children, right? So if the two oldest and being 14, 15 have mom and dad, and then there's a different father that has custody for the next two children, right? You can name one child under one power of attorney and then name a different child because you need the proper signatures. And so, right, if there's multiple dads involved and they each have custody of their own children, but the mom's the common factor, you can prepare however many of these the family needs. But most importantly, making sure the right parent is signing off on the forms, I think is imperative to be recognized so they have that custody. And then signing and then getting this notarized is the last step. And there's an additional sheet at the end here for the agent, and that kind of ties back into that financial piece for the agent to sign off on like, hey, yeah, I'm accepting this responsibility and I'm willing to accept this responsibility if that were to be the case, understanding that they will have to financially take care of the child and everything else, take them to school, take them to the doctor, all of the responsibilities seemingly as a parent, and they can sign off on that. This is not required, it's optional. Um, and then this last page is an option for parents who could be facing deportation, but they have a home address back in their home country, right? So that's where they'll end up, kind of thing. So if they're deported back to Mexico, let's say, and they have family and a house or whatever, they would be going back to in their home country. They can put down that address as well, address, phone number, email, just in case they can't be reached at that original address, phone number at the top. So again, just an additional contingency um, for families. And then I think that's the end of the power of attorney um, form on our end that we prepare. Um, and then jumping back into the PowerPoint, Courtney, sorry, I just have a couple of last slides. If you can share.
Yep, sorry.
No, that's okay. I'm rely on you completely. Thank
There
you.
we go.
Perfect. And then just some additional notes and considerations to round off this presentation for us. Right. So when working with families, mixed families without status, some parents or even siblings might not have status, understanding that this is a very vulnerable population and how you interact with clients from this background. They're just a vulnerable population, especially right now. They're very scared. We've seen low numbers at our office in terms of our immigration practice. We've seen low numbers at the MBLC because people are scared to walk out of their front door, and that comes back to being targeted by ICE simply by the way they look. The fear of, understanding that they can be stopped driving at any point, especially outside of Milwaukee County, right? Other police offices are working hand in hand with ICE. I think Wisconsin is up to being one of the first states to deputize officers as ICE agents. So, a Waukesha police officer can also work as an ICE agent, and so they don't have to make an additional call for them to come out and pick this person up, which is scary and terrifying. And hopefully it doesn't happen, but that's kind of, the population that is vulnerable and who we're working with when it comes to these specific forms. And being empathetic, but also realistic, right? And so understanding that detainment and deportation is a reality for a lot of people living in our state and across the country. It's just something that is hard, but that is a reality, and helping them understand that to being prepared is the best possible way to kind of combat that, right? Like there's really nothing to do if they don't have any avenue to adjust status through the immigration court, preparing as much as possible for themselves and their minor children is just kind of what it is. And so, not sugarcoating it, but delivering that message in the most empathetic way possible. Even for me, right? Like I don't know what it is to live through that fear, but I've seen it enough in my clients to, understand. And so, um, oh, this tangential question is actually more for our clinic settings, but a lot of clients will ask various questions like, oh, well, since I have you here, here are some questions about how do I protect my home, right? And so when it comes to the MVLC, if you have the knowledge base and feel comfortable, answering those questions outside of the wheelhouse of immigration or family that we presented here today, please do so. But if you need to, put them back in line, so talk to a family law attorney or an estate planning attorney more at length, feel free to do so. But that's kind of where we stand. And then I think our conclusion is just, yeah, to help prepare these documents is we want to keep families together, most importantly, and then be prepared and well informed. And then outside of this money, but yeah, any legal advice outside of that, out of your wheelhouse or expertise, we say limit, but I think the MBOC welcomes any participation from a volunteer attorney to help the client out as much as possible, even if it's not exactly in your wheelhouse. But that's all we have from our end. Are there any other questions?
Thank you both for being here. I will read the second part of the attendance code and give people the chance to mull over if they have any questions that they want to either unmute and ask or drop into the chat. But the second part of the attendance code is PIE. P-I-E, PIE. And thank you both so much. I mean, this is obviously very timely, and I think together we've developed a resource that's really helpful to the community. So we're glad to share that with everyone here. I also put in the chat, back when Angie was talking about it, the flyer for our new service. We're offering immigration assistance by phone so that people can anonymously, confidentially call in and get the answers they need to questions they may not feel comfortable coming to ask in person. So thank you both. Lots of thank yous in the chat. I'll give it another minute or two if anyone has a question.